Welcome to our presentation on Creative Commons. This presentation was done by Caroline Shazaro, Sophie Grudinskis, and Sarah Laughlin. So in this presentation, we're going to talk and go into detail about Creative Commons. The topics that we'll be talking about about Creative Commons are the history of Creative Commons, where you can find Creative Commons works, and how to get licenses. So first, I'll be talking about the history of Creative Commons. So Creative Commons is an American nonprofit organization made in 2001 by Lawrence Lessig. In 1999, Lessig voiced his complaints about how he was upset with the balance of public and private interests. They got in the way of free expression and ideas. That was the starting idea of Creative Commons. So the first time that Creative Commons went to court was in 2006. A man had sued a Dutch tabloid for using his photos without credit or telling him first. Luckily for the Dutch tabloid, they didn't need to pay any types of fees since the photos were under the Creative Commons non-commercial license, which is a type of license that will be explained later. So as time went on, the Creative Commons organization realized that one license wouldn't be enough for all the different works that could be under that license. So they made 5 other licenses, which will be explained later. These licenses are used for all different types of works and the work's intent. If someone wants to adapt and add on to a work and use it in, let's say, an advertisement, there's a certain license for that. One of the big milestones that the Creative Commons organization had hit was in 2009 when Wikipedia and other wiki groups had started using their licenses.
Where do you find Creative Commons work? How do you know when you find Creative Commons work? You know when you find Creative Commons work when you view something, you see the letter CC at the bottom of your website, document, or whatever you are viewing. The letter CC means that you are viewing Creative Commons work. You can find Creative Commons work through books, websites, ebooks, commercials, and so on. Authors and publishers wanted to have their work available under Creative Commons licenses because they wanted their paper copy books and transfer them into ebooks versions. Where to find Creative Commons? There are many websites and books to go to find Creative Commons work. YouTube, Skills Commons, CreativeCommons.org are all examples of these websites. Creative Commons also collaborates with many different medias. How Creative Commons is helpful when you find their work. Creative Commons is helpful when you find their work in many various ways. For example, Creative Commons licenses such as photography, film, and music give people permission to share their work without getting copyrighted. Authors and publishers can ask for their work to be edited or shared. They can also choose where their work is located. How to search for Creative Commons. If you're having trouble searching for Creative Commons, you can search many different websites that will help you create your licenses that you can add on to in the future.
Creative Commons licensing. What is a Creative Commons license? In short, a Creative Commons license gives people important information on what they can and can't do with your creations. Creative Commons licensing allows creators to set up specific rules as to how they want their work used. This also frees them from having to grant permission multiple times to every individual who wants to use their work. Each license comes with an attribution rule. The attribution rule states that users can share your work automatically, but they are required to know your terms if they plan to do anything else with it, such as change it in any way. Having a license is beneficial for your work. If you're a small creator, having long and extensive restrictions can prevent your creations from being seen by others. You don't want your hard work to be forgotten, so a Creative Commons license may be good. Now we're going to move on and talk about another type of license and protection called copyright. Don't you know those warnings or notices usually seen at the beginning of movies or video games? Does that sound at all familiar? So you might be thinking to yourself, well, isn't Creative Commons basically the same thing as copyright? No, not really. Well then, what is the difference? Creative Commons versus copyright. On the left, you'll see that we have a Creative Commons logo, and on the right, you'll see that we have a copyright logo. They aren't much different, the logos, I mean. Let's start off with Creative Commons. Creative Commons is a less strict way of sharing your work, rather than copyright, which tends to have more rules and restrictions in place about what you can do with others' creations. In a way, Creative Commons allows more creativity when you're using others' work. Next, we have the fact that Creative Commons doesn't relinquish copyright. In fact, if you already have a copyright license, it only adds on more freedoms. But if you don't, it's fine too. And lastly, Creative Commons is the licensing for small creators. It's easier to get your work seen if you are allowing people to use some parts of it. Let's move on to copyright. Copyright was said to impede creativity and artistic development. This is because of its strict terms on adaptations, such as song remixes or even shares. Because of this, copyright places obstacles in the way of people noticing your work. So if you're a small creator or if you are new, you might not want to use copyright. Here's a quote that helps explain the importance of Creative Commons licensing. It says, "While I want my work to get the widest possible distribution, if anyone's going to make money on it, I'd like that to be me and the people who worked with me on it." Creative Commons in the real world. Let's think about when and how you can use a Creative Commons license in the real world and if it's worth getting at all. We'll examine two real-world scenarios, the first being photo sharing. I watched a video that talked about a photographer with a Creative Commons license. A boy wanted to use her photo of a bird for his science project. And the boy was able to read this photographer's license and understand all of her terms easily due to the Commons Deed. What is the Commons Deed? It is a written document of your license instead of a confusing, lawyer-filled mess. It's actually human readable, so anyone who needs to see it can read it and understand your terms. Let's move on to our next scenario, book publishing. The article I read talked about an author who wanted to publish his books under Creative Commons. This is important to him because of the ebook companies using books without permission of the author and making money off of their work. Now, let's backtrack. This was back in 2005, and it was hard to find publishers back then to take the time to incorporate your Creative Commons license into their book. And yes, this was 2005, so ebook companies were new. In fact, a study done in 2005 showed that all books that weren't published under a Creative Commons license were put into ebooks for free. And not only did this raise printout book prices, but the author technically wasn't making any money on it because technically the ebook companies could take it. So our author here was happy because once he was able to get his license and his book published, his work was presented and protected like he originally wanted. Where can you get a Creative Commons license? As you can see here, I have a screenshot of what the page you should go to will look like. You can either access the Creative Commons licensing via the Creative Commons website, or you can search up apply for a Creative Commons license and the same result should come up. Creative Commons license, some things you should know. Creative Commons licenses were developed to give creators some but not all rights to the works of others. This was definitely more than what copyright did, and to this day it's helped so many creators to publish their work safely. Next, we have the fact that Creative Commons licensing includes copying, editing, remixing, distribution, and add-ons. But some licenses include all and some don't. It all depends on what you want. Next, we have the share alike license. This is a license that only gives permission to those who have a similar license to you to use your work. This is an important term to remember when searching for the right license for you. And last, we have the 3 layers of your license. You might recognize one of these. Let's start with the legal code. It is a readable copy of your license, but only something a lawyer would really ever need to see or understand. Like we said, the Commons deed is a human readable copy of your license, so anyone who needs to understand it can read it. And the CC rights expression language is the machine readable copy. You don't really ever have to worry about this one. This photo is an example of the 3 layers. What are the different Creative Commons licenses? Let's start off with the first one, Attribution CC BY. The CC stands for Creative Commons and BY stands for attribution. You'll notice that every license has the first word of it is attribution, which, as you might remember, you must know the creator's terms before using their work in any way. This first license allows creators to distribute, remix, adapt, and build upon your work. Commercial use is also allowed. The next license we have is the Attribution Share Alike, or the CC BY SA. This allows creators to remix, adapt, and build upon your work as long as they give you credit. And if you remember what share alike meant, it means that only creators with a similar license to you can use your work. Our next license that we have is Attribution No Derivatives, or CC BY ND. This allows creators to use your work commercially, but it cannot be shared with others in its new form. Also, credit must be given. So if I had a remix that I made, I could only use the remix for myself. I wouldn't be able to share it with my friends. Our next license we have is the Attribution Non-Commercial, or the CC BY NC. This allows creators to remix, distribute, adapt, and build upon your work, but they cannot sell or make any money from it. The Attribution Non-Commercial Share Alike, or the CC BY NCSA, allows creators to distribute, remix, adapt, and build upon your work as long as they give you credit and have a similar license to you. Also, they cannot make any money from this. And our last license is the Attribution Non-Commercial No Derivatives, or the CC BY NCND. This allows creators to download and share your works as long as they credit you. They cannot change anything or use them commercially, and this is also known as the strictest of the Creative Commons license offered. How to get a license. First, you'll want to visit the Creative Commons site. Here you'll be able to learn about all of your licensing options. Next, you'll want to use the license chooser, but if you already have one in mind, that's fine too. So after you've researched the best license for your work, you'll want to choose it. And lastly, you want to put your new license to work. Add your license to your work so others can understand your terms. Here's my works cited page.
Here's my works cited page.
And here's my works cited page.
Hi, my name is Sammy Mather, and for my subtopic, I chose History and Info. What is copyright law/license? What is a copyright license? In many cases, an author of an original work may gain an economic or other benefit by granting another person or entity the authority to exercise one or more of these rights, or even part of one of the rights. A transfer of rights in a copyrighted work can be accomplished through copyright license or assignment. Copyright law does not require that payment or anything else be exchanged in order to grant someone a license. What is copyright law? Copyright law is all about balancing the rights of authors with the rights of the public to use the work without seeking permission or paying royalties. Under copyright, authors have the right to control the use of their works, subject to exceptions permitted under the law. Copyright law in the U.S. is based on the Copyright Act of 1976, a federal statute that went into effect on January 1st, 1978. What are the two main parts of copyright law? Originality and fixation. Originality is a work is original in the copyright sense if it owes its origin to the author and was not copied from some pre-existing work. Fixation is in the Copyright Act. A work is fixed when it is made sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for a period of more than transitory duration. Where did the first ideas of copyright come from? On April 10th, 1710, the statue of Anne, Queen of Great Britain, is the foundation for British and American copyright law. On January 8th, 1783, Connecticut passed the first U.S. copyright statute. On May 31st, 1790, the first copyright law was enacted under the new United States Constitution. On June 9th, 1790, the first copyright entry was the Philadelphia Spelling Book by John Berry. It is registered in the U.S. District Court of Pennsylvania. How does copyright work? Copyright is a form of intellectual property law. It protects authors' original works such as literacy, dramatic, musical, and artistic works. Copyright does not protect facts, ideas, system, or methods of operation. For example, it doesn't protect an idea for a movie, but it does protect a movie script. Copyright is the legal and exclusive right to copy or permit to be copied some specific work of art. If you own something that is copyrighted, someone else cannot make a copy without your permission. The original authorship appearing on a website may be protected by copyright. This includes writings, artwork, photographs, and other forms of authorship protected by copyright. What is the copyright symbol? A copyright symbol, also known as a copyright notice, is a specific identifier that informs the public that someone has ownership over an original creation. Essentially, this means that creators of materials published or produced after the said date do not have to put a copyright sign on the notice on their work because they automatically enjoy the protection of the copyright law. In some cases, copyright can also help determine the term of protection based on the year of publication. Why use a copyright symbol? Having a copyright icon denotes that the work or material is someone's original creation. In some cases, copyright can also help determine the term of protection based on the year of publication. You should use a copyright symbol because no one can take your work and claim it as their own.
My name is Nora Plastry, and I will be talking about copyright laws. There are many things that are copyrighted, including magazines, newspapers, movies, books, music, and much, much more. All of these things have the same amount of copyright protection no matter how big or how small. There are also a lot of things that aren't copyrighted, including plots, settings, or characters of books, stage names or pseudonyms, government documents, or short sayings or slogans. It needs to be a physical, tangible thing to be protected, so ideas without physical evidence of it being yours isn't protected. Some of the first copyright laws in the US were the Copyright Act of 1790, and it stated that Congress could protect authors' creative works, but it only protected books, maps, and charts for up to 14 years. Many years, amendments, and laws went by, and the Copyright Act of 1976 came up, and it's the law that we go by today. It protects works from the moment it's created to 50 years after the creator dies. How and what are the ways that I can violate copyright laws? Only authors can do these things to their own work. They can reuse parts of their work in different ways. They can give out copies of their work. They can perform or display their work in public, and they can perform sound recordings on a radio. If you do any of these things to someone else's work, it is violating copyright laws. Plagiarism and piracy are the most common ways of breaking copyright laws. Plagiarism is taking and publishing somebody else's work and calling it your own, while piracy is reproducing copyrighted work without permission or illegally. How do people enforce copyright laws? If you get caught infringing somebody else's copyright, you could be taken to court and have to pay for the court and the lawyers. You could be fined from $200 to $250,000. You can be put into jail for up to 10 years if you have infringed before, and you could have the illegal work taken away from you. How do I use copyrighted work legally? There are a few steps to get permission to use a copyrighted work. You, one, have to find out if the work is still copyrighted. 50 years after the author dies, it expires. Number two, find out if you can use it under fair use. You can use small portions and not need to ask permission to use them. 3, if not under fair use, find out who to ask to get permission to use that copyrighted work. And 4, if requested, you have to pay a fee.
Hi, my name is Brooke Smith, and I'll be going over 2 famous copyright cases. The first copyright case I'll be going over is the copyright battle between Tracy Chapman and Nicki Minaj. What is the case? Recently, Chapman sued Nicki Minaj for using part of her song, Baby I Can Hold You. Minaj was accused to have leaked that song to a New York DJ. Minaj's attorney argues that the song Baby I Can Hold You was a demo created by Tracy Chapman and had not yet been published. Chapman had not yet published or gotten the copyright symbol on her work. Chapman sued, saying Minaj shouldn't have been allowed to make the unconsented song in the first place, but there was arguing with both sides saying yes, she could, even if it was a demo. What was the key point of the disagreement? Minaj was allowed to create the song under an exception to copyright law known as fair use. Who won? The judge decided that Minaj had won the case and did not commit copyright infringement against Chapman's Baby I Can Hold You song. This was no surprise to anyone because Minaj had already claimed that Chapman had already said she could use part of her song prior to the disagreement. The second case I'll be going over is Monkey Naruto loses legal battle for selfie copyright. What was the case? In 2011, the monkey approached the photographer David Slater's camera and happened to click the camera button and snapped a picture of himself grinning. PETA claimed Naruto did not own the copyright to his own selfie. PETA filed the suit in 2016. Who won the case? The photographer David Slater won the case and got to keep his photos on the books, the websites, and wherever else he put the pictures. Why did the monkey lose the case? The Court of Appeals stated an animal, included a monkey, may not sue humans, corporations, or companies for damages and injunctive relief arising from claims of copyright infringement.
Hello, my name is Jack Harris, and I will also be going over copyright cases. So the first copyright case, Basin versus Army Productions, Inc. What was the case? So the people in this case were J. Carrios Johnson and Gary Gildry, who are the co-CEOs of I'm Ready Productions, Inc. They are also 2 NAACP award-winning producers, which stands for National Association for the Advancement of Colored People. Michael Baston was a nationally broadcasted radio host. So the claim was that IRP, or I'm Ready Productions, violated federal copyright laws by touring a stage play without his permission and selling DVDs based on his novels The Maintenance Man and Men Cry in the Dark. So what happened? The jury found out that IRP had not broken any copyright laws in his novel, and they also found that they had a valid agreement allowing the distribution of the videos and that no monies were due to Bastin for that distribution. And another thing the jury found was that Michael Bastin gave authorization in 2005 for the tour of Men Cry in the Dark. So the IRP won this case, and all of Michael Bastin's claims were denied. But it was very stressful for the company IRP, and it cost them $2 million. In the end, the case took 3.5 years to finish. So the next case is Associated Press versus Shepard Fairey. So what was the case? So the people in this case are the Associated Press, which is a nonprofit news agency headquartered in New York City, and Shepard Fairey, who is a artist, and he made the Hope poster of Barack Obama. So the claim was that AP believed that this poster was their property, and that Fairey was guilty of was later identified to be AP property because they found out it was an AP photo shot by photographer Manny Garcia in 2006. So the AP said to Fairey that he needed to ask for permission to use the photo, but Fairey's attorney said that the use of the image is fair and protected by copyright law. So who won in the end? For this case, it was an out-of-court settlement, which basically means that they came to agreement without the need of involved. But by doing that, Fairey had a fair use right under copyright law to produce a poster off an AP photo. But in the end, the lawsuit took 2 years to come to an end. The final case is James Gordon versus DreamWorks Animation. So this was James Gordon, who was an ordinary guy, but he was suffering from bipolar disorder. And then DreamWorks Animation is an American animation studio, and Gordon sued DreamWorks in 2011, claiming the copyrights to Kung Fu Panda. So what happened? So he demanded a $12 million settlement, and his family tried to notify the judge that he had bipolar disorder and he suffered from emotional trauma. That emotional trauma being brother died of a heart attack, another brother died in a car accident, and his sister was murdered, and he was hospitalized for depression. So, but their attorney Jeffrey Denner said that he cannot raise an insanity defense because of the legal standards in the federal court system. So he later convicted by jury of fraud and lying about DreamWorks copying his drawings of Kung Fu Panda. He was sentenced to 2 years of prison, but it still cost DreamWorks $3 million to defend the case.
Creative Commons by Lila Jackson,
Lucy Royston,
and Coleman Carney.
Creative Commons is a nonprofit organization that helps overcome legal obstacles to the sharing of knowledge and creativity to address the world's pressing challenges. I'm Lila Jackson, and I'll be informing you on a brief history of Creative Commons and where to find works licensed with Creative Commons later. Who? The Organization of Creative Commons was founded by a group of intellectuals in December of 2002. This crew included a group of cyber law experts, computer scientists, professors, publishers, and filmmakers. Their names follow. They include James Boyle, Michael Carroll, Lawrence Lessig, Molly Schaefer von Howling, Hal Abelson, Yuri Saltzman, and Eric Eldred. The goal and initial purpose of the creation of Creative Commons is to diminish, or at least assist in the process of dampening the harsh and restrictive laws of copyright. As a global unit, reusing and sharing ideas is how we spread knowledge and creativity, which is what makes this founding so paramount. 1.4 billion creative works have been shared while using Creative Commons licensing to step away from copyright restrictions.
Hello, I'm Lucy Royston, and my part of the Creative Commons project is licensing and the symbols of Creative Commons. The first license in Creative Commons is Attribution CC BY. This license is the most common license for people to apply for and use. The first license lets others tweak, remix, and build upon your work as long as they credit the creator. The second license is Attribution Share Alike, CC BY SA. The second lets people tweak, remix, and build upon for commercial purposes as long as credit is given and is filed under the same terms. The third license is Attribution No Derivatives, CC BY ND. The third lets people redistribute commercially or non-commercially as long as it's unchanged and credit is given. The fourth license is Attribution Non-Commercial, CC BY NC. The fourth lets people tweak, remix, and build upon work non-commercially. The creator of the new product must credit the original creator, and they do not have to license it under the same terms. The fifth license is Attribution Non-Commercial Share Alike, CC BY NC SA. The fifth lets people remix, tweak, and build upon your work non-commercially, and as long as credit is given, they also have to license it under the same terms. The sixth license is Attribution Non-Commercial No Derivatives, CC BY NC ND. This is the most restricting license out of the main six. The sixth license allows others to download and share, but they have to give credit to you. They can't change anything or use them commercially in any way. What are licenses for? Licenses are designed for writings, art, photos, music, films, websites, and other things that could be stolen from the web or the internet. Licenses in Creative Commons are important to tell us what we need to do if we are going to use the information on various platforms. How do licenses help us? People want their work to be shared, but not manipulated by the public. These laws of Creative Commons make sharing work safer for the original creator. Licenses protect us from people stealing our work and using it for things they don't want people to use it for. Symbols of Creative Commons. These are the four main symbols that attach to the licenses. Nonprofit / non-commercial, money sign with a line through it. Cite, the person figure. No derivatives, the equal sign. Share alike, the reload symbol. Who? Lawrence Lessig is the creator of the Creative Commons symbols. He is also one of the founders.
Hi, my name is Cole McCarney, and I'm also part of the Creative Commons group. Today, I'll be teaching you about how to obtain a Creative Commons license and what the difference between a Creative Commons license and a traditional copyright license is. Getting a Creative Commons license is a rather simple 5-step process that is understandable, cost-free for anyone to do. The first and second step is by visiting www.creativecommons.org. Once arriving at this website, you'll find 4 main tabs to navigate the website. Click Share Your Work, then hit Get Started. The second steps are 2 questions that ask you how you'd like your work to be used. These 2 questions are allow adaptations of your work to be used and allow commercial use of your work. The third step is minor to the whole process, which simply asks you if you would rather have a normal or compact logo. This will not affect your license, just simply gives you a preference over the look of your logo. The fifth and final step is to copy and paste the link on the work you want licensed.
Again, I'm Lila Jackson, and now I'll be telling you about where to find works licensed with Creative Commons. Creative Commons works with many platforms to help share and protect creative works around the globe. Any works that fall under copyright laws is granted an opportunity to apply for Creative Commons licensing. Some commonly known platforms that Creative Commons works with include Flickr, Vimeo, and Wikipedia. Creative Commons helps license these works on these platforms to free creative pieces so that people like us can view them and use them. Works in the public domain do not qualify for Creative Commons licensing. Why? Works in the public domain don't fall under the laws of copyright. Public domain works are free to use by anyone. Because of works in the public domain standards, there is no need for Creative Commons licensing on them. As a little review, any of the following can be licensed: educational resources, music, photographs, databases, government resources, and public sector information, to name a few.
The difference between copyright and Creative Commons. Can you go back a slide? Thank you. The main goal of creativecommons.org creating a Creative Commons license was to provide an alternate license from copyright for creators looking to share their work under their own and protected terms. Next slide, please. The difference between copyright and Creative Commons continued. When you apply copyright to any work product, that licensed work now has all rights reserved. This means that any outside contributor cannot use the copyrighted work unless granted permission by the creator. This differs from Creative Commons license because the Creative Commons license was specifically engineered for creators to share their own work under their own terms, the opposite purpose for copyright. This is a visual review for what I just talked about, explaining the rights of copyright, all rights reserved, and Creative Commons, some rights reserved, and then briefly going over public domain.
Here's my works cited page.
There's my works cited page.
And my works cited page. Thanks for watching.
Thank you.
Copyright and Licensing by Ella Lynch, Finn Yamini, Nolan Seebeck, and Niam Freyk.
What can and can't be copyrighted? Lots of things around the world can be copyrighted. You can be a world-renowned author with millions of fans and copyright your book, or you could be a teenager in your room late at night and copyright a poem you just wrote. As you can see from my list, a variety of things such as YouTube videos and even works of art to just music in the background of a live stream can be copyrighted. While a lot of things can be copyrighted, there are still some things that can't. For instance, the taste of food or a computer program. You also may think a machine you just invented can and should be copyrighted. However, you actually need to get something different, which is called a patent. A patent is like copyright for inventions. The most important thing you can't copyright is an idea, which means that you can't just think of something in the shower and go apply it and get it copyrighted, which gives the world more freedom to invent and try new things.
Is copyright automatic? Yes, copyright is automatic once it is in tangible form. This applies to most creative works such as art, music, and writing. This gives you ownership of the work and still means no one can steal it. However, you can also file for an official copyright. An official copyright will give you a public record of your work and allow you to take legal action against people who try to steal it. Copyright infringement, both accidental and on purpose, is very common. In 2016 alone, 3,944 cases of copyright were filed against people. Do you need the copyright symbol? No. Although you used to need the copyright symbol to prove your work is copyrighted, this rule was lifted in 1989, and now the symbol is only there to help let others know the work is copyrighted.
Copyright laws and punishments. Some punishment violations in copyright law. Some of the copyright laws that are important is that if you copyright something and you get caught, you have to pay a fine from a range of $200 to $150,000 for every piece work infringement. You also could be sent to jail for extreme cases of copyright infringement. How strict is copyright? Copywriting things without following the rules and not sending a copyright or a copy to the Copyright Office means that you have to pay a fine. That's it.
Okay, copywriting and current events. So for this section of the slide, I'll be presenting some modern day copyright stories that have fell between the cracks of copyright law. Okay, so starting off, in 2011, David Slater is taking photos in Indonesia, Tanoco Batungis Natural Reserve. That is I definitely butchered that. When he leaves his camera equipment unattended. During this time, as you might be able to see in the bottom right corner, Naruto the monkey sees he has an opportunity and takes it. He snaps a selfie of himself and runs off. Slater later uses this selfie in his book published in 2014, that's where problems arise. So this is where things start to get bad. Wikipedia decided that to post the picture of Naruto on their page. And when Slater asks them to take it down, they refuse because they say he doesn't technically own it. Then PETA in 2015, or People of Ethical Treatment of Animals, sues Slater. The San Francisco judge inevitably ruled against PETA, saying that because Naruto is not human, the copyright laws don't apply to him. PETA appealed. The appeals court ultimately upheld this decision. Okay, now on to the second current event. By 2020, the video game industry is estimated to make $155 billion, which is $424,657,534 a day. A huge part of the success is the video game streamers live streaming their insane skill or humor. The biggest game streaming platform, Twitch, is under fire from the community mishandling copyright claims. Before May, Twitch had received less than 50 DMCA claims, or Digital Millennium Copyright Act claims. Since then, Twitch has been getting thousands of claims a week. Why is this happening and why wasn't it happening? Streamers have always used copyrighted music because they were told it was allowed because they were live. That's not what's getting copyrighted. It's the clips that the streamers make of funny moments and cool plays that they post on their streaming page. This was never a problem before because companies like Warner Brothers were unaware of the profit they could make from their copyright strikes. For many people, live streaming is their source of income, but they're being banned from the platform for these claims. They can come in hundreds for people who have been streaming for a while, and they're only given 3 days to manually delete, or the consequences will be into effect. Many streamers are fed up with the claims and their fellow community members being removed from the platform, so they are streaming with zero sound and making their own effects to replace the iconic sounds from Mario and other beloved characters.
Here are the sources we used for our project. There are a variety of Gale databases, websites, articles, and books.
And that concludes our presentation.